All right. So, these are the discussion topics we're going to be focusing on. First, the judicial admissions process itself, services that are provided. The most important thing to you guys, residential. I also want to briefly touch on recovery solutions, formerly known as WellPath, and some detention centers, and contact information. So what is the judicial admission? How does that process start? Well, first, basically it means that someone is charged with the commission of a crime. Okay, so that's where it starts. It starts in the criminal legal proceedings. At some point during that process, either the judge involved in the case, the solicitor, or the defense attorney suspects that that person charged might have a disability or mental illness that would prevent them from understanding proceedings against them. They may think, well, I don't think this person can assist in their own defense. When that is suspected, the solicitor public defender will request a competency to stand trial evaluation. And those competency to stand trial evaluations can be done through our agency or through the Office of Mental Health, or through a joint evaluation. If that legal team thinks that this person just has mental health issues, more than likely they will request it through mental health. If they think they actually have a intellectual disability, they'll request it through us. When a request is made and there's a suspicion that they might have that intellectual disability or a related disability, that request gets sent directly to our clinical services team. That is made up of our forensic psychologists and their staff. They're the ones who actually start. That is where the process starts for us with our agency. They get the information from the courts, they prepare all the records, and then they meet with that individual to determine if there is a competency concern. The purpose of that evaluation is, number one, determine if the person charged with the crime has the capacity to understand the proceedings against them. Number two, if that person can assist with their own defense. And number three, if there is a substantial probability that they can attain capacity in the foreseeable future, which is called a restoration. I do want to explain that there is a difference between a competency evaluation for a criminal hearing versus overall competency. They are two totally separate concepts. A person who is determined not competent to stand trial for a crime has no bearing on whether they are competent or incompetent to need like a legal guardian. That question comes up quite frequently. This competency is also only based on those factors. They're only looking at if they can assist in their defense as it relates to their charges, and if they understand the proceedings against them. That is the only thing they are reviewing competency on. For restoration, that is something that we typically see more often in individuals who also have a mental health diagnosis. So, for example, if an individual gets charged with a crime, but perhaps they have a diagnosis of schizophrenia, maybe they haven't been taking their medications regularly, maybe they haven't been getting any kind of treatment, and so their schizophrenia is not being well managed. Well, the courts can determine that, they might not be competent now, but if they go for restorative treatment, they go, to an inpatient, they get their meds regulated, they get therapy, they get full treatment, we'll come back and look again to see, okay, now that has been addressed, are they now competent to go move forward with trial? That is called a restorative process. That only pertains to if they have a mental health diagnosis. Our individuals who have intellectual disability and related disability, those are not restorable. Okay, an intellectual disability does not get better. An IQ score will not increase. We don't have magic medication, that can make somebody with ID or RD improve their status on that end. However, if they have mental health, that can be restorable with proper treatment and medication. So it is possible that we may have individuals in our services who also have that mental health diagnosis and can be ordered to go through a restorative period. When we talk in terms of the difference between our competency evaluation and mental health, and a joint one, if somebody is suspected to have a mental health diagnosis and they start that process and that reviewer determines, what, I think they might have an intellectual disability instead or a related disability, they will stop that evaluation and they will move forward to do a joint evaluation. So a lot of our individuals actually get what's called that joint evaluation. They have a reviewer from mental health and also our forensic psychologist reviewing them simultaneously for competency. Once the evaluation is completed, the reviewers then provide a copy of that evaluation to the court. If the person is determined not competent to stand trial and there is that indication of ID or RD, if they are not eligible for services at that time of that eval, our clinical services department initiates a referral to our eligibility division. So if they're not competent and our reviewer determines, we think they have a disability, they give them what's called a provisional diagnosis and they refer them for eligibility. So what the judicial admission hearing actually contains or consists of, after that report is sent to the court will hold a hearing. It's referred to as the Blair hearing, and that is going to determine whether the individual is actually competent or not. When the psychologists complete their evaluation, they are providing their professional opinion to the court. So that is their opinion. It is actually the final authority of the court to determine whether that person is indeed incompetent or not. So the court will then review the information, hear all of the findings, and they will make that final determination. They will then order, which means require the solicitor, if they agree with that evaluation that the person is not competent, they will order the solicitor to file a petition for judicial admission with the probate court or the family court. If it is a juvenile, those petitions can be filed either through the family court or the probate court. If they are an adult, they go through the probate court. And then we are then ordered, once we receive that petition, we are ordered to prepare what's called a diagnostic report to the court, which is basically kind of a summary of their competency evaluation and all of their history and charges. Once that is submitted to the court schedules the official judicial admission hearing, and OIDD is required to provide a plan of service to the court. And that plan of service basically includes recommendations from our agency on how the person will be served, where they will be served, how can they be best supported, so that we hopefully limit their risk of reoffending. That plan is submitted to the court. I provide testimony on that. OIDD is federally mandated to provide services in the least restrictive setting. Therefore, when we look at and make recommendations for where people are going to get services, that is a main factor that we review. You know, what is the least restrictive that this person can be served and get what they need. So who can be judicially admitted? Only people with an intellectual disability or a related disability, including autism, can be judicially admitted to OIDD. People that are eligible for our services under the traumatic brain injury category, spinal cord injury, or similar disabilities cannot be judicially admitted. And that is based on a decision in court. It's called the Lincoln decision. I'm not going to go too much into detail. If you're curious about it, you can Google it and it'll pop right up. But that is the legal decision and standing of why OIDD is not lawfully able to judicially admit people under that eligibility category. So what does this judicial admission mean? What is the ramifications of that? So OIDD is not a custodial agency. Being judicially admitted does not mean that we have custody of that person. We are not authorized to ever take custody of an individual. However, it does mean that OIDD has the final authority or the final say-so, if you will, on what services and where the services are provided to that person. So OIDD is responsible to provide the needed supports and services, in part to limit their risk of reoffending. In order for judicial admission is a legally binding court document. OIDD judicial admissions are in effect for as long as the person needs services. And I want to expand on that a little bit. So the way that our statute reads is that basically persons who are judicially admitted to OIDD will remain judicially admitted until they no longer need services. A person with intellectual disability or related disability, as long as they are eligible, they will need services because they have a lifelong disability. ID and RD do not go away. They are not restorable. They do not improve. Yes, we provide skills training for our individuals. We provide supervision, but that does not change their disability or their function, their IQ. It might improve their adaptive functioning, but it does not change their cognitive functioning. This is different than mental health admissions. Office of Mental Health judicial commitments are typically time limited. So, we may see an order where a person might be required to participate in outpatient mental health treatment for 12 months or be committed involuntarily to Bryan Psychiatric Hospital for 180 days. And once that timeline has been met, their order is done. That is not the case for individuals in our services. Typically, these are lifetime orders. People who are judicially admitted are required to comply with services and placement as determined by OIDD. People who are judicially admitted must receive active case management at all times. So this also includes, during periods of non-compliance, refusal of service, and incarceration. They should not be placed on inactive status. There are, exceptions that case management agencies can reach out in certain circumstances. If at any time the person who's judicially admitted refuses services or is non-compliant, then OIDD shall be notified. And if needed, OIDD will provide an update to the court, to whatever court they were judicially admitted from. This is the little handy dandy flow chart of where the process starts and kind of ends. So we see here the person is charged with a crime. Somebody suspects ID or RD and they do a request for a competency. If the person is found competent, then they must face those charges and whatever penalties of that crime. If they are found not competent, then the solicitor is required to petition for judicial admission. Our agency provides a diagnostic assessment and plan of service, determines the appropriate services and type of placement, and then that hearing is held and a signed order is shared with all relevant parties once received by our agency. This is the public index system. Some of you may be very familiar with this. This is how you can actually look up an individual in your service who might have criminal charges. So using the public index, I forgot the link, but I can certainly share it. You click on your county, and then you actually just put the person's last name and first name after you hit this agree, and it'll pull up all the charges that person has listed under them. If there are multiple entries, ensure that it's the correct person by clicking the case and investigating further, because, Joe Smith is a pretty common name. So you might have several Joe Smiths that pop up. So you'll want to click on a specific record. It'll usually, once you open the record, it'll usually have the person's birth year. So you can determine that way if it's the person you're looking for. The public index, I think as of January 1st, no longer publishes addresses in their record. So you will not be able to verify by address. And once you have clicked on the entry on the person, you'll be able to see everybody who's involved in their case. So it'll list the solicitor, it'll list the defense attorney, it'll specify the charge, if there's any sentencing. You'll just click on each to get more information. Some items to note about the public index. On the case section, there will be a disposition, what's called a disposition section. And that basically indicates what the outcome was to those charges. So when a person becomes judicially admitted, the disposition might state something like nol prost or dismissed. Usually when you see a nol prost, it's the same meaning as dismissed. You can investigate further in that charge to see what actions were taken. And if there was an order for competency, it'll be included in that action list. Once judicially admitted, the charges do not disappear or come off the public index. Okay, they're still viewable. That is important to note, especially for our residential, when you're looking to admit somebody. If you are attempting to admit a person to a HUD-funded property, though in essence their charges have been resolved, they still appear in a background check. So this may exclude some of our individuals from being able to reside in a HUD subsidized property. The only manner in which charges can essentially disappear from a record is through expungement. And that person would have to obtain legal counsel to assist in that manner, and not all charges are expungible. So that's something to keep in mind as well. I believe there's also some fees involved with expungement as well. A little bit about case management services. If you're serving people residentially, you have pretty extensive involvement with our case managers. But if someone is judicially admitted, they must receive active case management. They're required to. They should not be moved inactive without prior approval from OIDD. The case manager works towards accessing needed services. If the person stops adhering to services or is not compliant, they are to contact me. Residential habilitation, this is where you guys come in. A lot of times the person that's found to be incompetent may need residential habilitation services. So this is determined based on a comprehensive review of their file, the nature of their charges, if they have family or natural supports available, discussion with relevant parties. As I had said before, OIDD is required to provide services and supports in the least restrictive setting. So this decision is not taken lightly. All of these factors are taken into place to determine whether someone needs residential services. The consumer's case manager initiates that process by requesting a request through our residential process here. They send a request packet to our residential needs committee, and they will send referral packets out. The case manager and the residential provider will work closely together to ensure that all admission requirements are met. I also regularly assist in that process if there's, technical things that come up or there's state oversight needed. So I'm also available to assist. If the person gets admitted to a contracted placement and they are judicially admitted, neither them or their family members shall sign themselves out unless approved by OIDD. So they cannot just determine, I don't want to live here anymore, I'm leaving. That is state approval. However, they are allowed to go on home visits if appropriate. We definitely encourage family involvement, if it's appropriate. We actually wish more people could go home with family, but that's not the case all the time. So we do definitely encourage home visits if it's appropriate, that family contact. So placement at the time of the admission, again, OIDD determines the setting type. What's least restrictive for this person? Is it a CTH2? Is it an SLP2, etc.? Again, once placed, neither the consumer or family member can sign themselves out. Should the consumer leave placement without permission, so eloping, appropriate protocols by the provider will need to follow. So that would be a call to local law enforcement, a notification to OIDD, any critical reports that need to be completed. If there's any period of non-compliance of services on the consumer's part, again, OIDD needs to be notified. The residential provider will receive a copy of that final judicial admission order from OIDD with their responsibilities explained. Since I have taken over judicial admissions in this department, what I have been doing is once I get that signed order and somebody is in placement or going into placement, I send that directly to that admitting provider with their explanations included. That's something we're trying to work on in the back end as well, because I realize, previously maybe those orders aren't necessarily current, or maybe they've had another judicial admission since they've been admitted, whatever that case. I also want to make note that if there's a period of non-compliance, really the best is to try to talk to that person, even get case management involved, and maybe talk to that person first to see if you can get them back on track. If they are still not being compliant and still having issues after staff and case management has already done their piece and spoken with them, then definitely reach out to me at OIDD, and I will then have a discussion with that person, explain to that person, etc. really going to the court is kind of um, our last effort. We want to avoid taking them back to court if we can. We want to try to mitigate as much as we can internally before having to go back to court. So we want to give that person an opportunity basically to get back into compliance and get back into services. Another important note, because I get this question a lot, an appointment of legal guardianship or power of attorney does not supersede an order of judicial admission. Sometimes we have family members say, well, yeah, they're in this group home, but I'm their guardian and I'm going to pull them out. No, they cannot do that. They will have to go through the formal court process if they want to do that. The least restrictive environment. OIDD has the final authority on setting type and placement. If the individual desires to or is ready to step down to a lesser restrictive setting, it must be approved by OIDD and the judicial admissions manager. So ideally, this process would start with the individual's case manager. Typically they would do a location change request or a setting type request. If the person is in a CTH2 and they want to step down to an SLP, they would do that process through residential, but then the judicial admissions department would also be looking to verify, are they ready for a step down? Is this a good move? When talking about someone's status, there should be a call team meeting to review their current status, their behaviors, their progress, etc., just as you would do for any other status change. And then, once that's all determined, the case manager will make that formal request. And this also includes discharge to family and out of residential services. So, if a person is ready for step down or wants to go back to live with family, that does require OIDD approval. I want to talk about screenings under special circumstances. So sometimes our individuals who are going through or have already been judicially admitted may require placement directly from a detention center. So they may be leaving jail directly to a group home or from Recovery Solutions, formerly known as WellPath. That's our psychiatric detention facility here in Columbia. The case manager often works very closely with us to facilitate those screenings and obtaining needed information for admission. And we've been very successful with a lot of the detention centers to allow for virtual screenings. WellPath also does virtual screenings. They've been the ones that I've been involved with have been very willing to work with us, and they've been very accommodating. So we've been able to establish good relationships with a lot of the detention centers around the state. And quite frankly, they like to hear when we're having people screened because they want to get them out of there. Legally, if someone is not competent to stand trial and they're judicially admitted, they cannot be held in a detention facility. If anybody on your team is, or you're part of the screening process, I just want to kind of put this out there to be mindful of when you're screening our individuals, especially at places like WellPath. Do not, outright give them the impression that, yes, we're definitely going to take you, or we think you're great, we want you next week. Keep that part very vague and just truthful of, well, we need to get back with our team. We need to determine if we can support you in this setting and if you'd be a good fit. Some folks, have been told in the past that somebody wants to take them, or that the provider said, oh, we definitely want you, and then it fell through, or they weren't able to and ended up changing their mind. And it just, for people sitting in detention centers and places like WellPath, that can really be an area of frustration for them. So, what is Recovery Solutions? I just want to talk a little bit about that. So OIDD contracts with this provider to provide mental health treatment for our individuals who are involved in the criminal justice system. They also, contract with mental health. They do things like restorative treatment for people in the mental health system. They provide not only that mental health treatment, but a wide array of medical services as well. And of course, the residential piece. OIDD, we actually have our own designated unit at that facility that only our individuals can be placed in. And it's really catered to them and their needs. Admission and discharge to and from Recovery Solutions is initiated by the OIDD Judicial Admissions Department. Our department is the only ones that can initiate anything dealing with Recovery Solutions. And again, they provide those comprehensive assessments, evaluations, treatment, stabilization, all of those things. This is my contact information. So for anyone that you have who is judicially admitted that requires closure, escalation to higher, they're not compliant or we're looking to step down. This is my contact information, my email, my phone number. I've actually gone out and met with some of the providers in our state who serve a bulk of people who are judicially admitted, and I've met with them as a group. So if you think that might be something that would benefit people you serve who are judicially admitted, for someone to come and explain to them what their judicial admission means, why they're where they at, I'd be happy to do that. I've done that with a couple of providers so far, and it seems to be pretty well received so far. So that's kind of what I'm slowly working towards as I'm building up this department and kind of doing a lot more with judicial admissions. So I'm putting that offer out there.